Hey guys, in this video, we're going to talk about what it takes for a parent to get a green card through a child. If you're out there and you're preparing for this process, or if you've encountered some bumps in the road, watch this video because I'm also going to talk about some complex issues that can happen in cases like this one. If you have not yet subscribed to my channel, go ahead, subscribe right now and hit the notification bell. Now let's talk about this issue. When your child hits 21, he or she is eligible to file for you at that point. You've got to prove the parent-child relationship. It is a legal relationship. You're the biological parent or you're a step parent. Pull up the instructions for Form I-130 and look through the instructions for what documents are required to prove that your parent really is your parent and your child really is your child. Also, if you're here and you've overstayed your visa as a parent, your unlawful presence is automatically just ignored and waived, so to speak. So you will not need a waiver to adjust your status because you're an immediate relative of a U.S. citizen. But if you enter the United States without inspection, you will not be able to adjust your status through your U.S. citizen child. The government will require you to go overseas for an embassy interview, and be very careful with that because, as you always hear me say, you'll need a waiver before you leave the United States. You'll need that waiver approved because you have unlawful presence on your record. The embassy will not automatically forgive you for that if you go overseas for an embassy interview. You absolutely must get a waiver approved before you leave America. Otherwise, you could be barred from coming back for 10 years. The other issue that some parents face is over time, if they've been here, especially if they've been here in the United States and they didn't really have any options for a green card, over time, they may have filed certain applications for lawful status for, like, maybe they filed for under LULAC, maybe they submitted a VAWA application, and maybe they, along with those applications, they lied. They weren't truthful on those applications. It might be very clear on the record with the government that you had committed fraud or misrepresentation in the past. If that's the case, the government will require or ask you to submit a waiver. This waiver, guys, is like the first waiver that I described. This waiver will also require you to have a parent or spouse who is a U.S. citizen or green card holder. This is the roadblock that some people do face. And if you don't have the relative for the waiver, then you can't really go very far with your case. Your waiver will be the heart of you being able to get through, the heart of the case. If you have other special issues on your record, like maybe the perma bar, the permanent bar, then that's a different scenario. Or if you have on your record falsely claimed to be a U.S. citizen, then that's a problem. There's no waiver available for that problem. U.S. immigration laws are very narrowly written, and it's very frustrating, even for us lawyers from time to time, because we wish that there was a little bit more flexibility to allow for certain people to obtain the green card, but Congress has written it in a really, really narrow way. For parents who may be stuck because they need a waiver and they do not have a pathway through their child because they don't have a relative for the waiver, well, what can they do? If they're here in the United States and they've been a victim of a certain crime, they should get their case looked at to see if they would be eligible for the U visa. Also, if there's a concern of persecution, fear of future persecution if they were to go back home, maybe asylum would be the way to go, right? So these are humanitarian pathways. Or if they had been married, maybe to a U.S. citizen or a green card holder and they were abused in that marriage, well, they could also apply for a green card on their own. And then lastly, guys, there are other smaller issues that can crop up from time to time, such as maybe there's a problem with the birth certificate, right? Maybe it's hard for you to prove that parent-child relationship because maybe the birth certificate was issued many years after a child's birth, which is common in some countries. Cases like that, maybe DNA tests and other secondary evidence will be required to prove parent-child relationship. So guys, those are some of the issues. We work on all of them. We work on all of these issues that I've discussed in this video. If you have any special issues going on with your case, have a lawyer look at it before you do the filing. Make sure that it's done correctly, because even though you may have your 21-year-old child and you think, yes, now it's time, if you have these special issues going on, you may want to take a little step back, have a professional look at your case to see how to move forward. Okay. Before you leave, don't forget to sign up to our firm newsletter, subscribe to it. Get on the newsletter, go to McBeanLaw.com so that you can get our Q&As and other information that we email for free each week. Hope you've enjoyed this chat. Be sure to share it with others, comment below, and guys, I will see you in the next one. Bye-bye.